dispute. And that's the point where we start talking about what pathway to take when it comes to dispute resolution, when in reality, this decision should be made at the very onset where a relationship starts, where negotiations begin, where people come to the table and say, we'd like to work together. That's essentially where these conversations should begin. However, we're not seeing a lot of that, and it's important that we're having this timely conversation today. So just to introduce the panel that we have today that will help us follow through that journey from the point where they begin at the negotiation table and parties we're thinking of whether to escalate or maintain the relationship as is, or rather protect the parties within the particular transaction by mending it, and then going all the way to the point where there's breakdown in relationship, and then it's to be the resolution of that particular dispute. So I'm happy to introduce the panel that we have today. As I've stated, it's quite an exciting panel. I give credit to the CIAB actually for making sure that we have all these perspectives, as you'll see. So allow me to introduce Emobon Nuvie, Alfred Majamite from Nigeria. Emobo brings a very interesting perspective because he sits at the intersection of in-house litigation, operations and arbitration in ADR. He's currently operations and legal counsel at British American Tobacco for Nigeria and Kenya, where he manages the business litigation and ADR portfolio while also advising its operations and supply chain. Before moving in-house, he practiced at Punuka Attorneys and Solicitors, where he rose to partner and headed both the property law and arbitration and ADR practice groups. He acted both institutional and ad hoc in both institutional and ad hoc arbitrations, and has served as a sole arbitrator and arbitral secretary. Emobo has expertise from both sides as external counsel and inside counsel. So help me welcome Emobo to today's panel. You can just use the tab.
Thank you very much, Brenda.
Reaction.
Yeah. Everyone, looking forward to the discussions. Thank you.
Thank you, Emobo. Then we'll move to Paula. Now, Paula is in-house, but also just like Emobo, she also practiced in-house as in-house counsel, but currently sits as legal counsel at Mortar Angel Africa, where she advises on some of Africa's most significant infrastructure projects and works at the intersection of infrastructure, cross-border transactions, and contractual risk. Before she moved there, she was also in-house counsel at Denton's. And I think Paula gives us a very important perspective for today's conversation because she's very much front end of the relationships where transactions are being structured, contracts are being negotiated, and risks are being allocated before anyone is thinking about arbitrations, tribunals, getting external counsel. She's also passionate about making construction law and ADR practical, commercial, and accessible. Paula, it's wonderful to have you on the panel with us today.
Thank you, Brenda, and thank you to the Chartered Institute of Arbitrators, YMG Steering Committee and Organizing Committee. It's a pleasure to be part of this panel and be in conversation with my fellow esteemed panelists. And thank you, Brenda, for creating and curating a very well thought out conversation. I look forward to having this discussion.
Thank you very much, Paula. And finally, allow me to introduce Ben. Ben Sanderson, who's a fellow of the Chartered Institute of Arbitrators, is an independent arbitrator and practices as arbitration counsel as well in Madrid and London, with more than 20 years of experience in international commercial and investment treaty arbitration. He represents states, multinational corporations, and international organizations in complex disputes across mining, tech experience in disputes involving Africa and Latin America. He's also acted under ICC, LCIA, ICSID, UNCITRAL, PCA, and SEC rules, and has represented governments including Kenya, Zambia, and Uganda in investment treaty disputes, and regularly sits as an arbitrator. Allow me to also mention that he was just recently appointed at the Nairobi NCIA. He'll tell us more about that during the introduction. But I'm happy to have you on today's panel, Ben, as well, so that you can give us a perspective as an arbitrator, but also as counsel appointed, external counsel appointed into this litigation, into this dispute resolution matters that come across your desk.
Thank you very much, Brenda, for the very kind introduction. As you mentioned, I've worked for the government of Kenya in the past, representing them in disputes. A real delight to be able to join this conversation with you today. So thank you for the invitation.
Thanks so much. I'm sure you can already tell it's going to be a very, very interesting conversation that we're having today, not a normal Friday. But allow me to start with Paula. Paula, let's start with you because we want to start at the very beginning. Before there's a dispute, even a conflict arises, when parties are coming together and saying, we want to work together, and it's essentially either cross-border or even internal transactions. What are the things that in-house counsel should already be thinking about at the onset of that negotiation?
Yeah, sure. Thanks. I think it's the last thing that in the negotiation party's mind. So as in-house counsel, I have to unfortunately of the risks and how they impact my client, and then figure out who controls the solutions behind mitigating these risks and who has the financial capacity to absorb these risks. So those are the practical considerations I have to look at and then make a list of the risks that would be involved. So in terms of the risks, the principal risks I would consider, especially a developer and infrastructure in an infrastructure field, is construction risk. In most of the contracts, we are coming in and we're being given the mandate to construct, or we also enter into subcontract with local subcontractors. So the most important risk is to the most important thing is to take into account the construction risk and see whether we have the capacity, technical and financial capacity, to undertake the works that we have been mandated to do, or the subcontractor also has the technical capacity to do that. So in mitigating some of these risks, such as performance and construction risk, is to look at perhaps performance securities, payment guarantees, and things like that. Next, and perhaps also just as important, is political risk. In infrastructure projects, most of the time we are entering into large contracts with government institutions, and political risk is one of the things that comes out quite clearly. There are instances of changes in law, delays in getting permits, licensing, changes in political regimes. In Kenya, for example, there's a big conversation about Beyond Vision 2030. So you have to consider what contracts were entered into at the time when the development agenda was 2030, and you have to consider whether, if there's a new president, for example, and such contracts are terminated, how is your client protected? How are the termination payments treated, and are we able to satisfy our obligations even to the lenders? And that takes me to another risk, which is financial risk. You can have a very good project, it has the social backing, there is need for it, but is it a financeable project? Are you able to bank it? Are you able to introduce it to the relevant lenders to get finance for that project? Most infrastructure projects have a very large capital expenditure, and the financing is normally split between the financiers and the developers, with the financiers taking the bulk of the financial risk. So that's something that you have to take into account. Make sure the financiers, when they're coming, they're comfortable, they're happy, it's a bankable project that they can be able to get back the money they put in. And then lastly, and perhaps most relevant to this discussion, is dispute and enforcement risk. As you can imagine, there are very many stakeholders in such projects. There's a lot of money involved. There's a lot at stake. So if there was an instance where there was dispute, is this dispute able to be solved amicably within the timelines? Are you able to enforce against the party that you're in dispute with? And things like that. So that's just a small snippet of the main risks that I would consider. But most importantly is to not only draft a contract that looks good, but also, number one, assesses those risks and mitigates them.
Thanks so much, Paula. Before I even hand over the mic to another panelist, you brought out a very interesting part of this conversation: risk allocation. When you speak about ADR and how essentially you decide on how that will look like from the negotiation table, would you essentially say that ADR is something that's genuinely negotiated at that particular level, or do people just turn to boilerplate clauses and say we're going to key companies in large transactions? Tell us more about that.
I think you raise a very good point in introducing the boilerplate conversation, because it reminds me when I was a bit younger in my practice. Normally you find that these are contracts. So sometimes you don't pay too much attention to those clauses. You pay attention to the commercial intention of the parties and things like that. So previously, those are things that and the more I've seen how disputes revolve, you understand that this also stands at the heart of allocating risks that I would consider is number one, the location of where the contract is being performed. Normally, it is standard practice to have the project agreement, the governing law in the project in the country that the project is. So that is kind of the basis of the contract, and then it flows down to other contracts. Of course, there are contracts between lenders and other DFIs who would prefer governing laws in countries where they are domiciled, but from the beginning, when you're looking at the governing law of the project agreement, it's always easier to have the governing law in the country that the project is being performed. And then other things that would dictate, for example, the choice of dispute resolution. There are some FIDIC contracts which require a tiered approach of dispute resolution. So if you choose a certain suite of books, it literally governs how the dispute is supposed to move, and you don't immediately go to court or you don't immediately go into arbitration. So the kind of contract you're using also has an impact on the governing law and negotiations of those kinds of provisions. And then when we are choosing, for example, the seat and the forum for arbitration, for example, if that's what we go for. And I just have to say that for most infrastructure and construction projects, you find that we gear towards arbitration mostly because of the confidential nature of those projects. And also it's necessary to have some technical expertise to govern this contract. So if we end up going for arbitration, we want qualified arbitrators who are well known to make decisions that are fair and impartial, and can be able to satisfy the needs of not only the project parties, but the financiers as well. And then also when I talk about the financiers, there are some who just prefer things done a certain way, and we are bound to follow what the financiers would ordinarily want. So again, it goes to the bargaining power of the parties in the contract, and sometimes we might be forced to take the approach taken by the financiers. Cost is another big one. Of course, sometimes the dispute there could be, a valid claim, but when you look at the commercial impact of that claim and the cost behind it, it just doesn't make any commercial sense to go for the whole arbitration thing. And it might be better to just settle internally. So you also think about the cost and the time implications of going into whatever dispute resolution mechanism that you end up choosing.
Thanks so much, Paula. I think it's very good to understand that from the negotiation perspective, where parties are still at very early on stages, where they say we essentially want to work together. And you've brought in a very important perspective where certain parties have more power, and essentially, some of the clauses will be drafted to benefit them. It could actually be, seat of arbitration, and determine how enforcement will be at the end of the day. They want to make sure that if they're bringing money into the project, at the end of the day, they're able to either get it back or have the project benefit them at the end of the day. So that's a very interesting perspective that you bring. Now, before I go to the operational side of this contract, thank you so much, Paula. Ben, sitting from the other side where, you've seen matters have gone wrong, what would you say at the negotiation phase people should look at? Because they already have come to you with a dispute, and you see probably this is something we should have thought at the negotiation phase, or they should have thought at that particular stage where Paula takes us through, the parties coming together and they're saying we want to get into this transaction. What do you necessarily think has been overlooked at that particular stage that we could pay more attention to?
Thank you, Brenda, for the question, and thank you, Paula, for the kind of the overview of the kind of the risks at the beginning of the project. I guess one of the biggest I always see is just lack of due diligence on who your counterparty is, and particularly this comes up with government contracts and governments going to foreign investors and trying to find the right person for whatever project, but they enter into contracts without really understanding who the counterparty is and whether they're actually capable of fulfilling the project. They may have said nice things in a tender document and a pitch document, but the reality is that they may not actually have the capacity to do the project. So on a commercial project or a government project, spending however much it's going to cost, $10,000, $20,000, $30,000 to do a bit of due diligence, perhaps hire a third party to really dig into the company, the counterparty, I think it is money very, very well spent. Then the question that Paula raised about the last minute clause, that can be avoided by having not a boilerplate, but having what I call the decision tree. So my first goal is if I'm in Kenya, I want Kenyan law, I want the Nairobi Centre, and I want Nairobi as a seat. But obviously, if I have a foreign counterparty, that may not be possible. So then what's my next step down? I try and retain Kenyan law. I try and retain Nairobi Centre, but perhaps I put the seat in London, but the hearing's still in Nairobi. So I've given some compromise that the English courts will have supervisory jurisdiction rather than the Kenyan courts, but I still actually kept the majority of the dispute Kenyan. And just playing with those different metrics, I think, helps parties understand better what their own negotiating position is, that it's not just one party who has the power, that you don't have to give everything away immediately. And then the point about political risk, I think, is very important. And I think what some investors, domestic investors, overlook is that they can still have the benefit of bilateral investment treaties if the vehicle that actually enters into the contract with the government is registered in a country which has a bilateral investment treaty with the other country where the investment's taking place. So that investment structuring can provide some effectively another form of political risk insurance by the route of a bilateral investment treaty.
Thanks so much, Ben, because then I think it's very important, just as yourself and Paula have mentioned, we need to look at when getting into a contract, or rather an agreement, we need to look at it in an all-rounded manner. And it's very important that some of these issues are not overlooked at the beginning, because then once we run into a problem later on, it becomes more expensive to solve. Thanks so much, Ben, for your perspective on that. Now, Imobo, allow me to come to you. So the agreement has left Paula's desk. Essentially, we're talking about the legal counsel who do negotiations and contract drafting. What would you say at the operational stage, from your perspective, do things start to go wrong? And when I say this, I mean, at what point could you say that it stops just being an operational problem? It's now a legal problem.
Right. Thanks a lot, Brenda. And this is an excellent question. I think that oftentimes parties, like Paula had mentioned when she was speaking, forget that there could be problems, because at the beginning stage, everyone is, in a bosom relationship. And so parties tend not to avert their minds to unforeseen events and who would bear the risks and the consequences of those unforeseen events, right? So I've seen contracts where there wasn't a hardship clause. So what tends to come to mind is force majeure, because that's a bit more popular. But then I've been confronted with a contract where there wasn't a hardship clause, and then we had to devise a means to see how we could invoke hardship as a legal principle. You have other problems too, like who bears the risk of defective products, for instance, if that hasn't been thought of. And I would advise that there should be clear KPIs really that are objective, where you have clear matrices by which these KPIs will be evaluated. Because I've also, from experience, seen that whilst the contract managers would have something in mind, their counterparty has a different thing in mind. So if you're saying, for instance, responsiveness carries a weight of 20%, how do you assess responsiveness? Is it by saying within 48 hours, they've responded to a business communication, for instance? Is it something subjective, or is it something objective that you can pin to actual matrices? So I think that at that contractual stage, it's important to put all these things in black and white in the contract, so that you don't run into problems when you are now administering those contracts. Thank you. I think Brenda might be having some technical issues. Okay.
Yeah,
So just wait for
but
her
maybe just to add on what you said, Emobe, in my experience, contract relationships don't break down in one dramatic event. It's normally a series of things that have been boiling, as would be in the case in any kind of relationships. It's normally a series of things that have accumulated and have not been addressed, and then they end up being unresolved, and then it ends up blowing up into a big dispute. So my experience has always been to have a direct relationship with the operational teams and have conversations with them on an ongoing basis, perhaps having weekly updates, because some of these things I see are things that can easily be resolved if in-house is involved at the early stages before they blow up to be something that ends up in dispute.
Agreed.
So just one practical way of managing that is people tend to give very little consideration to the notice provision in contracts. But actually, if you have a notice provision which requires in-house counsel, senior managers, whoever it is in management to be notified, then immediately you avoid that problem where a notice gets served and an employee, for whatever reason, just sits on it and thinks they can manage it independently. But actually that escalation is part of the contractual notice. So that happens automatically. And, some organizations are extremely large and it's difficult to manage the workforce. So if you have that just set out in the contract, that's a risk mitigation for the company itself, that they're aware of what exactly is going on all their projects.
Thanks so much, Mobopola and Ben. I think this was I dropped off for a minute there, but when I came back, I was able to pick up on the conversation. I think it's very important that we're having all these perspectives, because then there's escalation. At what point do we make sure that even internally we have risk mitigation? Because as we've stated, party to party, there's sort of management of risk at that level, but internally then also there needs to be that open channel of communication, just to make sure that some of this relationships and issues are managed internally, and everyone's working together internally, just to make sure that there's that management of issues before they get to the point of disputes. So thanks so much for that perspective. I really want to go back to Mobo, because there's a perspective that I think it's important that we talk about it, and that's contract management. As we've stated, the contract has moved from a point of where it's been drafted, and now there's operational realities attached to it. So in terms of internal record keeping, when you're trying to prevent a disagreement from becoming a formal dispute, how do you ensure that there's that open communication internally, just to make sure that everyone understands what the responsibilities of the company is internally, so that there's no issues occurring from sort of that lack of clarity of responsibilities internally? Mobo?
Yep. So in my organization, we have performance evaluations, periodic performance evaluations, which are honest conversations between the contract managers to see how, this contract is being executed, right? And that's definitely something that I would propose happens often, perhaps not weekly. That might be too much strain. But more importantly, I think that even the contract managers themselves need to sit with their legal counsel to understand the rights and obligations of their employers, respective employers. And I say this because sometimes when they receive contracts, the contract managers may not understand the ambits of what they're to do or not do, and they just see it as legalese. And so when there's an issue, they've gone with their limited and perhaps misconceived understanding of what that clause means, and they've run with it, and then they have a problem, and it now comes to the legal counsel's desk to solve, and which speaks to what Paula had mentioned earlier about, ensuring that that space is properly managed. And even what Ben had said too as well about the notice clause, I would definitely advise that the contract manager is not necessarily the same person as who notice should be given to, because it then allows for a higher level of hierarchy, an escalation. So if the contract manager is unable to manage whatever disputes might be brewing, the moment a notice is then given to, someone higher up, a GM, a head of operations, whatever it is, that person is then able to look into it before it goes into a full-blown formal proceeding and a dispute is being declared. And I think the last point I would also mention on this is that an agreement to agree is not an agreement. When we're drafting our clauses and we're saying parties shall negotiate in good faith, XYZ, then you don't need to even put that clause. You simply wait for that event to happen and then negotiate. But putting it there doesn't make it an agreement. So as much as possible, reduce into writing every single thing that you expect from the other side. I have a friend who runs this legal series, and he once mentioned that the most dangerous clause to his mind is the clause that is not included in the contract, because that now leads to so many conjecture as to what the parties intended at the time. And perhaps the individual persons who negotiated that contract may have exited the business. And so everyone is struggling and grappling for what could have been the meaning, through emails and all of that discovery. So importantly, contract managers, understand your contract, seek legal advice as much as possible, have your periodic performance evaluations as well, and as much as possible, reduce everything into writing, into wet ink. If you need to have 2, 3 addenda as a result, then so be it, because you are preventing a dispute. Or if when that dispute then comes about, at least there's a template or a card that can be referred to. That's what I would say.
Thanks so much, Mo. But you raise a very important point when it comes to internal escalation and performance reviews, because then there's a wording of the contract itself, then there's the spirit of the contract. And as you've said, some things are negotiated on the table, but not enough pen is put to paper to just show the different parties what your obligation is. And if it's been stated, has that been clearly notified to internal members of the team? Do they know what essentially could cause problems because there's there's ambiguity in what the obligations are by the specific party. So it's very important that we actually spoke into that, because then internal teams could actually cause disputes for the company itself. Before I move to Paula again, I just wanted to probably get into a very important aspect here. How do you balance the competing responsibilities where there's been change in management? For example, you recently joined BAT and you found there's probably an issue that could escalate into an actual legal dispute, but you still need to protect the legal position of the company, while also trying to protect the commercial responsibility that may be still worth saving.
Well, I guess this is where your people skills are called into question, isn't it? What I would do really would be to convene a meeting, even before expressing my legal analysis in letters or emails and that sort of thing. Try and understand what the commercial objectives were at the time, right? If there were emails that could be forwarded, read those so you have a bit of background as well. And then, first of all, understand your internal position within the organization, then have the meeting with your external stakeholder, right? Try and reach some middle ground. It's interesting that you've asked this question, because this has actually happened before, where parties were divergent in opinion on 3 issues. But after the meeting, we're able to agree on 2 of them, and it remained just 1. And thankfully, during negotiation stage, we're then eventually able to resolve even the last one. The other party eventually conceded to our position. So I know that as legal counsel, as arbitration practitioners, there's sometimes that temptation to show our intelligence, which we have. But it's good to balance the commercial objective of your organization as well. You don't want to throw away the baby with the bathwater, right? And it's not to say that you should sacrifice the legal position on the altar of commercial objective, because that could also come back to bite you, where you then take a wrong legal stance, right? You may have solved a short-term problem, but then long-term, it creates another problem for you, right? So for instance, say a liability clause. It's incredibly important that there's that alignment as to whether you want a blanket liability because of the type of services that this vendor or supplier is going to be providing your organization, or are you willing to cap such liability? And if you're capping such liability, are there carve-outs that you can rely on, such as maybe fraud or intentional malfeasance, right? If you don't pay close attention enough to some of those kind of clauses, and you just think that you want to quickly solve this problem in the here and now, you would find that if there's then a big problem that exceeds your liability cap, for instance, you don't have any route for remedy for your organization. So it's a fine balance that must be struck.
Thank you so much, Mobo. I think this is a very, very important perspective that you shared with us. And it just brings me back to Paula, knowing that the people who eventually operate the contract that you've already drafted may interpret it differently, or rather implement it very differently from how you perceived it at the very beginning of the negotiation stage. Does that essentially change how you draft it at the onset?
It does. It does. I tend to, number one, use very simple language. I know in the past lawyers wanted to show their verbose nature in having very long and winded, like for example, in the definition clause, there was a lot of cross-referencing, and that tends to overwhelm and exhaust the reader. So I try and make the contract as simple and as reader-friendly as possible. And then I try and include the operational and technical teams as much as possible when drafting the contract. Practically, what I do is you find that some of the contracts are almost similar, like a consultancy contract, for example, would have almost similar provisions. So I try and extract the most important provisions out of that consultancy agreement and have the operational teams complete it. And then we have a meeting and it's clear to them what the implications this would be if they are included in the contract. And then constantly having those conversations with them, as I said earlier. I just don't take a back seat once the contract is signed and I'm happy that I've done my job. I'm always, involved in the performance and involved in those weekly meetings, even if they're technical, of a technical nature. It's always good to participate and be able to pick up if anything comes up, because sometimes, as I said earlier, these disputes don't happen just once out of a dramatic event. It could be a misunderstanding of the contract managers or the technical people, or it could be something that has been dragged for a long time and, maybe affects the other interfaces, and people managing one contract might not be able to tell how this would affect another contract. So that hands-on approach, making the contract very simple and accessible to the users, and being constantly available to provide any clarifications to the team. Because at the end of the day, the contract is drafted for the people who are implementing them and not for judges, hopefully.
Thank you so much, Paula. I think you raise a very fair point, because then legal should essentially work as a backbone of every transaction and not be seen as an independent facet of the business, because everything that they do is actually managed by a certain agreement. And if that's not well catered to at the beginning, and even when there's a realization, there could be a difference with how the operational team is handling it, then there'll essentially be a problem. So even as Mobo stated, coming back and saying, yes, we agreed that we would negotiate in good faith once that comes up, but can we have an addendum to the main agreement just to make sure that there's clarity on this? And if there's any changes, then that is also notified to the other parties and also internally. So managing that across the board becomes very important. Thank you so much, Paula and Mobo. Ben, when a matter eventually arrives before you, how much of operational history actually matters or becomes important to understanding the dispute at hand?
All of it. I mean, you want to go right back to the very beginning and understand the entirety of the relationship, because the dispute that presents has a whole backstory which will come out at some point, but it's never there in the first papers. And even sitting as an arbitrator, you read the first pleadings and there's another story here, which I haven't yet heard. It's going to come out, it'll probably come out in cross-examination, which from the client's perspective is the very worst time for that story to come out, because they have no control over the direction at that point in time. So I guess thinking about from the like an in-house counsel perspective, if your external counsel are not asking those questions, really probing, really wanting to speak to witnesses, you've got the wrong external counsel because they're not trying to find the full story. And that inquisitiveness kind of interrogation needs to go on from day one to the final day of the hearing or the day of the final submission, because there's may always be something, an additional piece of information which could be key to the case.
Thanks, Ben. You raised a very fair point, and I think it's very important that we take our time here. Now, I'd want to go back a bit to mobile before I get back to you, because I really want us to take time here, because now this is a point where we're now engaging external counsel. Mobile, before it actually gets to that point, and you've realized there's now a serious breakdown in the relationship. There's a serious disagreement, and then now we need to transfer this from in-house counsel. Even, Paula, feel free to chime into this conversation, but, you realize we can no longer hold it or manage it internally. It's now a commercial issue that we need to formally escalate. How do you go about that?
Okay, so I think Ben already alluded to some of the considerations that I would have in mind in terms of the sort of advisors or external counsel that I would want to engage, right? When I was still in private practice, I acted as counsel to an FMCG company, or rather against an FMCG company, I beg your pardon. I was counsel to a power energy company that had done an energy plant for an FMCG company. And when that company wanted to engage us, it was clear that there was some sort of beauty pageant going on, because immediately we came in, we saw two other law firms sitting in the reception saying that they also had a meeting with their CEO and finance team. So it was very clear that it was about, the person willing to convince, them. And what struck me, we got the instruction, but what struck me was that it wasn't so much our technical competence, because I think that the other law firms in question also had that technical competence, but I think that we're asking the right question, because when they gave the summary of what the disputes were, and then we're asking questions relating to what had been agreed in the tariff and regarding the tariff and, the matrices that were able to be used in calculating that tariff and all of that. It was clear that more information was being extracted. So we weren't just taking what they had given us at surface value. And I think that's what gave us a little bit of leverage. And so applying that now that I'm in-house, I'm looking for counsel who don't just want to take what it is that my witness has said, because my witness might be giving only half the story. And there might be something that perhaps they're not too proud of to say, maybe because their line manager or head of function is there. But this is crucial information that if we're able to better manage it. If it's something that we need to admit liability and then negotiate a reduction in liability, we're able to take that decision at that time, as opposed to it coming out during cross-examination, which is a terrible time for it to come out. And then, we're at a loss, So I want inquisitive counsel. I definitely want counsel that, or advisors, not just counsel now, because there have also been matters where you need to do some kind of financial accounting, right? So you want finance experts, damages experts as well. There are the number of organizations that provide those sort of services. And again, it still speaks to the technical competence of those organizations. I recently took a gamble with a firm that had only done an accounting firm that had only done a damages assessment once. But then I felt persuaded that they had the capacity to. And I was very happy that my gamble was not against me. Again, perhaps also going with your intuition in determining if this is the right fit for the particular claim that you have, that you want to prosecute or that you have against you. Yeah.
Thanks so much, Mo. But I think I'd also want to hear Paula's perspective on this, because both of you come, you're from acting as external counsel. Now you both see the perspective of being in-house counsel. So Paula, I'd also want to get your perspective on that.
Yeah, sure. I think Mobo has raised very good points in terms of the technical expertise, going with kind of the vibe you get from, the lawyers that you want to appoint. Another thing that most people sometimes look past is the availability. In most of these disputes, you need urgent relief. You need to have a lawyer who is available on call. You need to have someone who is able to, commit resources and time and associates to some of these cases. So you find that a law firm might look good on paper, it's tier 1, it's well ranked, but they just don't have the capacity to deal with the case, with the urgency that you need. So sometimes we end up going to smaller law firms that have the capacity to do the work, but may not be as highly ranked as the tier 1 law firms. The other thing is also having a local expertise. There are some things that can only be understood from a local perspective, and it's always good to have hands on the ground for people who understand the local nuances. A good example is sometimes you find that people who don't operate in a market want to commitments as to timelines, as to when things are done, or when you can obtain a permit, for example, and that ends up affecting the life cycle of the project and becomes a source of dispute. And then someone simply tells you that in this kind of government institution, they just work when they want to work. And that's not something that you can hold against the party that was supposed to be seeking the license. Things like that, having local nuances, being available, having the right team on board who has practiced on such matters before is something that I really take into account when appointing external counsel.
Thanks so much, Paula and Mobo, for giving us that perspective. I'd like to go back to Ben quickly before we go into now the dispute settlement itself. Ben, so you've been appointed as external counsel, speaking from that perspective. At what point do you now say, let's have a conversation and let me understand the realities on the ground before I can take on a matter? Because that also determines how well you represent your client. And as Mobo also mentioned, sometimes you may find a team member is not completely honest about where the breakdown essentially happened, or something that may have happened that caused the escalation. So at what point, how do you go about that essentially as external counsel?
The very first step I do in every case is have a site meeting. Usually my clients are not based where I'm based. I have to travel and go and meet. And actually being in the office, being in their environment, there are so many messages that you just pick up on just from what's going on around, and listening and overhearing conversations and just being present and seeing the dynamics also between the team. Because you can have a great relationship with the GC, but perhaps some of the junior counsel, there's friction there or something. And actually to understand that really then helps you as external counsel to understand the real dynamics and offer kind of the best assistance really to navigate that process. So that building that relationship is absolutely fundamental, and that is not done over a computer screen or over a telephone. It has to be in person.
Thanks, Ben. I think that's very important, because then, coming from an external counsel perspective, you'd want to build that relationship where, if an internal staff is open to come to you and tell you, we just had a meeting here, but I think there's something important that is key before you come to cross-examination, then it comes out and blows up on your face. These are some of the issues that you want to dive in at that particular point where you're appointed. So thanks so much for that perspective. Now we talk about the relationship breakdown itself. And before we go into the dispute resolution, I think I'd want to give 5 minutes to our audience if they have any questions up to where we've gotten to dive into the discussion, probably just ask a few questions that they may have before we go to the last part of the webinar. Also, as we proceed, please feel free to use the chat box. I'll be looking at the chat box so that I can be able to share the questions with our panelists and make sure that at the end of this webinar, all questions you may have are properly addressed by the panelists we have here. As you can see, we have so much wealth of experience and expertise on today's panel, and we would not want not to take advantage of that. So thanks so much. So we'll just proceed. Now we're on the other side of, wait, did I see a hand? Or, okay, all right, fine. Feel free to use the chat box area so that we can, proceed with the webinar. But now we're on the other side of cross-border disputes. We've been talking about disputes generally throughout this call, but what changes when the relationship essentially crosses the borders? Now, Paula, when you deal with infrastructure projects across different jurisdictions, and as you've said, you work at a very interesting intersection where there's so many stakeholders involved, where essentially there's multiple parties in an agreement, or in any given transaction, there's multiple parties there. What cross-border realities make dispute avoidance or resolution more complicated?
As you rightly mentioned, the nature of such disputes are complex because there are different stakeholders involved, spread across different jurisdictions with different systems of law even. So that presents a challenge because some may be governed by civil law, some may be governed by common law, and that already is an area of conflict. The other thing is the presence of government institutions, for example, which presents risks in the contract that would not be as easy to price or control. An example is, as I mentioned before, political risk. If you have a president who comes with a whole new set of laws, or there's a change in law, that's not something that we can be able to adequately predict. And while there have been some measures to manage those risks, such as political risk insurance, it always adds an extra layer of costs and adding another party, and it becomes a bit more complicated than what you'd ordinarily have in a contract where parties are based in the same jurisdiction. Again, because of the nature of the many contracts involved in such cross-border transactions, is that there's a lot of interface risk. So you're dealing with, for example, the employer, the contractor, the financiers, the independent experts, engineers, architects. All these people have contracts governing them. And sometimes an action in this contract might lead to an implication in another contract. And if the team is not cohesively managed, you can have a case where something was negotiated in this contract, a notice, for example, that affects a notice in another contract, and there's a gap. So those are some of the complications that come up, and they force us to really be intentional about having a well-streamlined team that understands all the different facets of the contracts and the jurisdictions involved and the parties involved, and to manage those risks that would ordinarily come up.
Thanks so much, Paula. I think, it's very important that you spoke to that, because I was just about to ask him over the same thing, because he operates between Nigeria and Kenya. And I essentially wanted to get his perspective on how that looks like in terms of the business practice on ground, regulations, and the institutional realities operating across.
Sorry.
Movo?
Hi, Brenda. Sorry, I think I lost you for like 3 seconds.
No worries at all. So Paula was sharing the complications with dealing with different operational realities on ground, especially when it comes to cross-border transactions. And I just wanted to get your perspective as you operate across Nigeria and Kenya. How do differences in legal systems, regulators, business practices, and institutional realities essentially affect dispute management?
Oh, okay. Yes. So I agree a lot with what Paula had already mentioned. But just to build a bit on that, for instance, if you are negotiating these sort of contracts in terms of having to manage when disputes could arise, you want to consider if you then get an award or a judgment, whatever it is, against the counterparty, are you able to, does this counterparty have assets in a jurisdiction that is friendly to foreigners, to foreign investors, or is it a jurisdiction that is largely protectionist or nationalist, right? So if it's the latter, then you, even at the jump, you already want to start devising strategies to see how you'll be able to recover whatever award or ruling that you are able to get from the dispute resolution process that you go through. Because I think it would be a futile and Pyrrhic victory if you go through, wonderful arbitration that perhaps you have the privilege of Ben representing you as counsel, and then you are unable to recover anything because, the assets are not in a country that would typically allow you to enforce. So that's definitely something that you want to look to when you're looking at cross border disputes. Then again, we spoke about it a little while ago. I think it was the decision tree. I like that phrase. I've never heard it before, but it's good to hear where where I'm a Kenyan entity, my counterparty is perhaps Romanian, right? But then the contract is to be performed in Kenya. So usually I would insist that governing law be Kenyan law. Reason being that if it's any other jurisdiction, what might be unlawful in Kenya might be legal there, right? So, for instance, a contract for the procurement of guns might be legal in, I'm presuming, an American jurisdiction, right? But it probably would not be legal in an African jurisdiction. And so if you are using governing law as, an American jurisdiction's law, you have a huge challenge because the tribunal has to apply what it is has been decided to be the governing law, right? And so I usually would advise that the governing law should be the law of the lex situs, essentially, where the contract is to be performed. But then you can then compromise on other issues like the seat of arbitration. So that one you can then say, let it even be a neutral arbitration, a neutral jurisdiction. So like an England or a France, if it's civil entities that are contracting. Again, reason being that in yielding to the seats of arbitration of the counterparty, you also don't know the attitude of courts in that counterparty. And whilst they are not looking at the merits of the arbitration, they could frustrate your arbitral proceedings. So you want to get a subpoena to compel a witness to come, and the court refuses that subpoena and quotes some kind of national law that prevents them from doing so, right? Or you want to object even perhaps to something that the arbitrator has done, and you've gone to the court of that counterparty's jurisdiction. So I would usually say a neutral jurisdiction for the seat of arbitration, and then you can have maybe the place of arbitration, the physical venue where the arbitration would be in the place of your counterparty. I mean, subject to, I would say, some perhaps due diligence in terms of safety concerns as well, to ensure that, okay, your witnesses and your C-suite officers that you may be sending to the counterparty will be safe when they go to the other countries, what's it called, venue, that sort of thing. So those are the kind of things that will play in my mind, in addition to what Paula has also mentioned.
Thanks so much, Amobo. Ben, you've seen this practically from both an arbitrator perspective and an external counsel perspective. And by this, I mean dispute lawyer. Now, from where you sit, or rather from your experience, this 20 years that you've been in dispute resolution, have you been engaged at any given point at the drafting stage, very early on stages where you're able to predict or avoid disputes at the early on stages? Or are you usually just engaged at the point where disputes arise? And how does that look like essentially for you?
Thank you. So usually when the disputes arisen, but there's still then an opportunity, and I always want to have a conversation with the clients about, okay, this is the dispute clause that's in the contract, but we can propose a different dispute clause now if we want. So mediation, conciliation, whatever other steps that, having the directors have a meeting and speak, all those options are still available. I think people, there's a risk sometimes of getting a little bit short-sighted and just seeing what's in the black and white on the page in front of you and thinking that you're stuck with that. Of course you're not. This is a commercial relationship that exists between two parties. This dispute may not be the entirety of that relationship. There may be other factors, other projects or other contracts which are still ongoing. So I always encourage, both acting as counsel, but also when I sit as arbitrator to the parties, the first procedural meeting, I'm always saying, have you had discussions? Have you had negotiations? Do you want a window to do that? Do you want me to help conduct some of those conversations, or do you want a third-party mediator to come and be involved? Obviously, the disputes lawyer, the external counsel, often doesn't have that incentive, because their incentive is they want a long dispute, they're going to get some nice fees out of it, and that they're not in the settlement mindset. The really good external advisor is telling the client all the time throughout the whole arbitration, what about settlement? What about settlement? Keep raising that question, because things change, commercial relationships change, the dynamics change. And I think what you don't want to do is be in a position where you have one or three arbitrators determining something that's incredibly important. If you can get an amicable solution, that's always the best solution.
Thanks so much, Ben. Before I move back to Paula, you come from a perspective where you've represented states, and, both Paula and Mobo did mention it becomes more complicated where states are involved in an agreement. Where do you see the greatest asymmetry here between, both sides, and because you've acted in both matters where there are states and commercial parties?
So first of all, the huge asymmetry acting for a state is about information, because information is disseminated across multiple ministries, multiple departments. Perhaps there's been a change of government. So the commercial party is always at a huge advantage, because they know what they're doing, they know what the project was about, they know what's gone wrong. Whereas the government is often, it's a lot longer process to reconstruct the story. The other biggest asymmetry is back to the issue of settlements. Obviously, commercial parties, can settle relatively easily. There's a chain of command of how you make that decision. Within governments, and I have managed to negotiate settlements with state parties, but it's much more complicated. One, because of where is the chain of command, who ultimately has authority, but then also the huge risk that it is perceived, rightly or wrongly, as potentially corrupt. And so I know what some governments do. Colombia is one example. They have an independent body committee, a permanent committee, which reviews all settlement agreements. So it's taken out of the hands of the lawyers who will be managing the disputes, out of the hands of the ministry, and it just goes to an objective group of people to give another set of eyes and to give their go ahead for the settlement. Because if not, the paranoias exist. For example, I've worked with the Peruvian government, and they say we never settle. If we settle, there will be an assumption that someone has received a bribe. So they just don't go near settlement, and that's just a huge lost opportunity for states to save costs.
Absolutely. Thank you so much for that, Ben, because then I think many parties, when they're going to, getting into relationships with governments, as Paula noted at the very beginning, sometimes contracts tend to weigh more heavily on the party that has more influence at the very beginning when negotiating. So then it becomes a problem at the end, because we're getting to the point of enforcement, which also becomes an issue where you've gotten an award against a government. How then do you enforce against that particular government becomes an issue as well. Are you able to speak on that?
Is that for me again?
Yes, that's for you, Ben.
So enforcing against governments is, that's actually relatively straightforward, because, commercial assets always exist somewhere, and that's not, it's a laborious process, but there's always money somewhere. The flip side of that is when states win disputes that have been brought by investors, how do states enforce against that investor? Because that investor typically is a shell company that's been set up with a project, and it doesn't have the assets. So this takes us right back, I think, to my first comments on this webinar about due diligence. And actually, who are you contracting with? Because it's not just good enough to have a contract with the project company, but you need a guarantee or a signatory as well from the parent or someone else, because that's how you protect your enforcement risks down the line, by having as many parties as possible who are ultimately liable. And the way that you do that is that they're all signatories or guarantors under some contract or agreement with the arbitration clause, so they can be brought into the arbitral process as well.
Thanks so much. That's a very great perspective. Paul, I wanted to bring you in here at the enforcement conversation. How do you think enforcement considerations influence decisions made at the contracting stage for you?
They do. In fact, that's one of the most important considerations, especially for us when we are entering into contracts with government, because there's always that fear of, will we be able to enforce against, a government? You're given will we be able, is there impartiality, first of all? If we have the governing law, the seat, the venue in the same country, are we able to enforce against that government? Taking from one hand and asking from the other, that's always a consideration. And in the absence of an outright clause that, is mandatory under the law, we normally prefer having some neutrality. Having, for example, the seat, like everything independent of where the country is. Of course, you can have the governing law, as I said earlier, governing the contract, but at the end of the day, when we're thinking about enforcement, for us, it gives us a bit more comfort to have some neutrality. And I think I wanted to ask Ben what his experience has been when he said that it has been easier for him enforcing against the government rather than the private party, especially where the government, where the private party is outside in another jurisdiction in Europe, for example. How easy is it to enforce a decision that has been made here and the assets are going to be in a different country?
Yeah, well, enforcing against a state, I mean, virtually all those enforcements that I've done have taken place in New York. And the reason being is there's always bank accounts in New York, and states have commercial funds which they're using for commercial purposes. So that journey 80% of the time, I would say, leads either to the New York courts or to the Washington, D.C. courts. Obviously, then when I've worked on the state side enforcing against commercial parties, that becomes much more complicated because there's usually 2 or 3 jurisdictions where you're possibly looking at assets. And states then have a reluctance to effectively throw good money after bad, because what they're trying to enforce usually is a costs award that they've had in their favor, rather than compensatory damages, because states aren't usually suing for damages. They're usually on the defense and they've won the case. And what's one process I've gone through to help both sides in enforcement is third-party funding, because third-party funders are then once assets have been identified, they're usually very keen and willing, obviously, to help fund that litigation, which can be expensive, but obviously for a 20-30% of the winnings usually. But sometimes that is as it were, the additional cost mitigation that either companies or governments will be prepared to undertake to not keep spending more money on the litigation, but actually get someone else to fund it, and they're prepared to forfeit part of the recovery.
Thanks. And if I might just add, Brenda, I think enforcement is normally a last resort. So we try as much as possible to build into the contract mechanisms where we can get back the money in ways that do not involve going into arbitration, for example, insisting on letters of support, insisting on guarantees from the government and things like that. Inbuilt into the contract as much as possible, mechanisms that reduce risk, so that by the time we're going into enforcement, we really have exhausted all the other mechanisms that we have in place.
Thanks so much, Paula. Thanks so much, Ben, for that perspective. I think it's very good, Paula, that you did mention it's actually a last resort, because you also want to make sure that you're not spending too much money following on enforcement, that by the time you actually get it, it's not worth it anymore. And would you say that it's true for you as well?
Oh, yes. You definitely do not want to throw good money at bad money, right? And so if you perceive that you go through this arduous and cumbersome process and you're not going to be able to extract any real value, from it, it would certainly weigh on your mind in the strategies that you want and risk mitigation measures that you want to embed in the contract to prevent that from happening. So like Paula had mentioned about the bank guarantees, I mean, ideally, the bank guarantees would be drafted as not to require an award of an arbitral panel or a judgment before they are payable. But I've also seen bank guarantees payment obligations, and then the ones that secure payment of an arbitral award, an award debt or a judgment debt, right? And says once you provide an authenticated, award, we will pay. And there's that. So that's definitely something that I would also offer and pursue, as opposed to having to seek out where my counterparty has assets when I have an award in my hands.
Thanks so much, Amobo. I think this is also practiced, heavily by arbitral tribunals as well, between commercial parties, where they say, let's have a bank guarantee, where we just ensure that this process is going to go all the way to the end, especially where there's state parties involved, just to make sure that as the matter progresses, they're also protecting their time as well. So thank you so much to our panelists. And before we close out, because we've had very good discussions today, and I see there's a few questions coming in on the chat box, which I'll get to. But just speaking from the very onset, because Ben did mention that there is a place for dispute lawyers at the very beginning when contracts are being made at the negotiation table, where they say we can avoid this or we can do this. I'd like to ask this across the panel and bring us back to where we started at negotiation, knowing everything that you know about how cross-border disputes work and actually unfold. If you could go back to the day where the contract or agreement was being negotiated, what's one thing you would insist that the parties get right? We can start with you, Paula. Paula, can you hear? I think you're muted, sorry. And would you like to start? And then we get to Paula once she's reconnected.
Sure. So one thing I would absolutely insist on that the parties get right would be the seat of arbitration and the governing law. I would absolutely insist on that because I foresee that a lot of issues could come out from that. So from the onset, it's important to have a clear direction on what law would be applied to the merits of the disputes, and then what law would guide the arbitral procedure. So that's what I would insist on.
Thanks so much, Imobo. I would like to move to Ben, and then we can come back to Paula.
Thank you. Mine is just about back to knowing who you're signing a contract with. So really understanding the counterparty, not just about the assets and the parent companies, that things, but what is their business? What are they doing? What other projects do they have? Because if you understand their business a bit better, you could understand where possible pinch points may be in this contract. So if you know they've got a big delivery on another project that's due in 6 months' time, their attention may be focused on that rather than on your contract. So just to know and understand that, and actually have very frank conversations about things outside the contract with your counterparty, that you're entering into a business commercial relationship here. So there's very good reason why you should actually really understand them. It's a bit like getting married. You don't get married at first sight. You meet, you go on a few dates, you meet the family, you meet the friends, because that gives you a better understanding of the person. And it's exactly the same with a contractual counterpart.
Thanks so much. It's good that you likened an agreement between transactions to marriage. Many people, do the inverse, but it's very similar. You want to know who you're getting into bed with. Thanks so much for that contribution. And lastly, I want to go back to Paula. Not so sure whether she's reconnected, but
yeah. Can you hear me?
Yes, we can hear you now.
Sorry, I was having problems with my sound. I think if there's something I would do differently, would be to not treat the dispute resolution and governing law clauses as a boilerplate. Be very intentional about that. Probably the tree that Ben mentioned is something that I'll take up going forward, and also involving all the stakeholders at the very beginning and having a standardized system that would apply to all the contracts so that they can read into each other and there's no gaps and inconsistencies between the many stakeholders involved.
Thanks so much, Paula and Ben and Imobo. I think this is a very fitting place to end because the message has come out very clearly. ADR doesn't begin when the dispute comes up between the parties, or rather when there's a breakdown. It begins very early on, in how we structure the relationships, in how we allocate the risk in the transaction, how we draft the contracts, how we manage them internally once they're operational, and how we deliberately prepare for the possibility that the relationship may actually break down. So thank you, Paula, Imobo, and Ben, once again, for bringing these different perspectives into the conversations today. And before I thank everyone for joining us, I did see a question that came through from Ochil. Hope I got your name right. And he did say this on a light note and said, if in-house recognize and sweep all the clauses that could create disputes, what will dispute lawyers work on? Laughing emoji to that. Any experiences integrating dispute lawyers early on at drafting stage so that they can predict, troubleshoot, avoid preventable disputes? Insightful webinar. Thank you. So thanks, Ochil. I do believe that we did dive into this because I did ask Ben's perspective, but if any of the panelists across the board would like to answer to that, you're also free to chime in and respond to that particular question. But thanks once again to our panelists for taking their time today.
If I may just weigh in on that question very quickly.
Yes.
Something that we've done actually is to have external counsel review our contracts, not necessarily for dispute risks actually, but more for regulatory risks. Audit those contracts, and something that had come up was anti-competitive clauses, right? Where some of our clauses had been judged as being lopsided, and so could likely be struck down by the regulatory authorities. So I do think that to answer the gentleman's question, that there's definitely opportunity for dispute lawyers to also even review those contracts at the contract stage, because at the end of the day, you are the ones who see these disputes on a more regular basis, right? In-house counsel, we want to prevent those disputes, but then sometimes they are inevitable. Another instance would be where the way it has been drafted, you don't realize that a court of law could strike it down. To give a Nigerian example, penalty clauses are unenforceable at common law, right? And so if you are an in-house counselor and you've been one all your life, you might not know that. That's something that you would only know from practice in courts. And so your external counsel can give that advice. And so where instead of drafting interests as penalties for late payment, for instance, you're drafting them as liquidated damages. Essentially the same purpose, but different wording, different language, and then you're able to achieve the same objective. So that would be real value that you would have gotten from your external counsel, and you're able to enforce it if you need to enforce it, right? So please, we are collaborators in this, and we promise, whilst we'll try and sweep all the clauses, right, we'll definitely still rely on your expertise as the dispute resolution practitioners. Thank you.
Thanks so much, Mobo. Is there any other panelist that would like to take on Ochel's question? I do feel like he did a good job with that. So, Ochel, I hope you feel that your question was adequately answered, and thank you so much for also thanking the panelists for being with us today. I think this is a great place to hand over back to Siab, YMG. Thank you so much to everybody who's joined us today and this panelist. Feel free to get in touch with them on their LinkedIn. I think it is their the names that do appear on today's webinar. And yeah, carry on the conversations from there, because ADR is not a one-time thing as disputes arise. It's an everyday thing that should be discussed and addressed. And I believe the association is there, CIAB is there to ensure that we're seeking out knowledge from each other and sharing as much information as we can. So thank you. Jotham?
Yes, Brenda, thank you so much to everyone, to the participants, and most important, and to the panelists for that insightful discourse about ADR in cross-border realities. I believe it has been a very insightful conversation to all practitioners across board, whether in-house, external. We've got to hear perspectives from all angles as to that effect. From the YMG desk, we'd like to extend our invitations to all of us, to all our future engagements, all our future programs and events that we have lined up for you. So much is in store for all of us. So we'd like to urge each and every one of us to be part of the conversation, part of YMG programs and everything. I can see Takuka conference poster has been posted. Maybe I'll hint to it. We have the Takuka conference coming up sometime in October. I'll invite all of us to join us as we partake through it.